I have a First Amendment right to say whatever I want. That's a phrase that can stop even the most experienced HR leader or supervisor in their tracks. But it raises an important question, one that comes up more often than we think about. Do employees actually have a First Amendment right to be free from workplace consequences for what they say, even when it's away from work and off the clock? Today's case, Hedgepeth v. Britton, asks a hard question. How far does free speech go when your words disrupt your workplace? Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. And on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. I recently did a short about creating a hostile environment, specifically when it came to making controversial comments at work. And the response, it was incredible. There were so many thoughtful, engaged comments in that discussion that it really made me want to dig deeper into the topic. So today's case is designed to do just that, to get you thinking a little bit more about how this plays out in real life and to help you understand your rights so you can protect yourself and feel empowered if something like this ever comes up at work. Okay, let's get into it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. Jean Hedgepeth had spent 20 years teaching social studies at Palatine High School in Chicago, Illinois, but her record wasn't spotless. She'd been disciplined twice before. The first time was back in 2016 after a classroom lecture about the presidential election. During that lesson, she used phrases like forking lie and freaking deported. The district suspended her one day without pay, saying the language violated policy and warning her that future incidents could lead to termination. 3 years later, in 2019, came another problem, a heated exchange with a student in the classroom. She told the student, "You haven't done your forking homework." Language wasn't just unprofessional, it was seen as crossing a boundary, a clear boundary between teacher and student. And the district responded with a 4-day suspension, issued a notice to remedy, and required Hedgepeth to attend 6 counseling sessions. Those 2 events would matter a lot later. Then on June 1st, 2020, in the midst of nationwide protest and civil unrest that followed the death of George Floyd in Minneapolis, Hedgepeth went on Facebook and posted vacation photos with the caption, "I don't want to go home tomorrow. Now that the Civil War has begun, I want to move." A friend replied, "Follow your gut, move." And she answered, "I need a gun and training." Next, she reposted a meme. "Want to stop these riots? Mobilize the septic tank trucks, put a pressure cannon on them, hose them down." The end. She added, "You think this would work?" In another exchange with a former student, she wrote, "I find the term white privilege as racist as the N-word." And it didn't take long for her post to circulate through the community. By the next morning, Tony Medina, the principal of Palatine High School, he was flooded with messages from parents, students, and teachers. Those messages poured in and they were escalated to the superintendent, Lisa Small. The district was flooded with phone calls, emails, even media outlets wanted statements. The district released a public apology saying that Hedgepeth's post did not reflect the values of principals of District 211 and apologized for any harm or disrespect that the comments may have caused. Later that week, Hedgepeth met with James Britton, the HR director. Britton reviewed her disciplinary history, including the 2019 notice to remedy and the flood of community complaints. Britton gave Hedgepeth an opportunity to explain her posts, and he also told her that an investigation would follow. And just a quick note, if you're someone who handles workplace investigations like an HR leader or a small business owner, this next part is especially important because what you do and how you do it, it really matters. A half-baked investigation doesn't just create risk, it creates liability. That's why I've built a full investigation playlist right here on my channel and a Planning the Investigation workbook to go with it. You can find the link in the description. After Britton completed his investigation, he drafted a memorandum to the superintendent recommending dismissal. About a week later, Superintendent Lisa Small and HR Director James Britton met with Jean Hedgepeth to go over the results of the investigation. Brighton reviewed what the district had received, the flood of emails, media inquiries, and disruption inside the school. Then Lisa Small spoke directly with Hedgepeth, and she told Hedgepeth that based on her prior disciplinary record, the seriousness of the Facebook posts, and the impact they had on the school community, she would be recommending to the board that Hedgepeth be terminated. Hedgepeth was alarmed and she pushed back. She said her posts were personal opinions protected by the First Amendment and that she had a right to express them. But Lisa Small noted something she later documented in writing, that Hedgepeth showed an absolute lack of any understanding or appreciation for why many people found her comments objectionable. That meeting would be the last time Hedgepeth sat across from her employer before the formal dismissal process began. After that meeting with Superintendent Small and HR Director Britton, the decision moved to the next level, the Board of Education. But by June and July of 2020, Hedgepeth's case had become a community issue. At the June board meeting, 58 public comments were read, some defending her, but many condemning the Facebook posts as inappropriate for a teacher. By the July meeting, the conversation had grown even larger, with speakers focusing on diversity, inclusion, and accountability within the district. After reviewing the superintendent's findings, the HR investigation, and the public feedback, the board voted to terminate Hedgepeth's employment. The vote marked the official end of Hedgepeth's 20-year teaching career at Palatine High School. Hedgepeth requested a dismissal hearing before a neutral hearing officer with the Illinois State Board of Education. Those hearings were held on March 10th and April 9th, 2021, where she called witnesses, cross-examined, and argued her case. Afterward, the hearing officer took the matter under advisement, meaning no final decision had been issued yet. Now, while that process was still pending, on July 15th, 2021, Hedgepeth filed a federal lawsuit, claiming her dismissal violated her First Amendment rights. And more than a year later, on October 26, 2022, the hearing officer issued her findings of fact and recommendation. Those were findings, not the final decision. And the hearing officer concluded that Hedgepeth's Facebook posts violated the 2019 notice to remedy, that last chance warning she'd received after her 2019 classroom altercation. Also, that her conduct was irremediable because it compromised beyond repair her ability to continue to function effectively in her role. Her post destroyed any possibility that she could be viewed as a fair and honest arbiter in students' expressions of different perspectives. In court, Hedgepeth claimed that she was not fired because she did anything wrong at work, but because of her personal opinions, her personal beliefs that were expressed off the clock on her private Facebook page. In response to Hedgepeth's lawsuit, the district said, "We didn't punish her for her opinion. We disciplined her for how and where she expressed it. The disruption it caused in her failure to uphold the professional standards required of a teacher." And the district court agreed with the school district, and so did the Seventh Circuit Court of Appeals, which issued its decision on August 26, 2025. And here's what the appellate court said. Teachers and all public employees do have First Amendment rights, but those rights are not unlimited. The court acknowledged that Hedgepeth's posts following George Floyd's death were indeed matters of public concern. But then it asked the second question: did the school district's interest in maintaining an effective and inclusive environment outweigh Hedgepeth's right to express those views? And the court said yes. It found that her comments, especially those comparing white privilege to the use of the N-word and suggesting violence toward protesters, undermined her ability to maintain trust and credibility with students, parents, and colleagues. The decision pointed out that she taught in a racially diverse public high school. Her posts had already caused disruption in the community, including complaints from students and media coverage. The court determined that even though her speech was private and off-duty, it had a direct
and detrimental impact on her effectiveness as a teacher. Therefore, the district's actions were constitutional. Her firing did not violate the First Amendment. The court reaffirmed an important principle: free speech protects you from government punishment, not from workplace consequences. So before you post, before you make comments in the workplace, ask yourself this question: could this comment be seen as targeting or disrespecting people I work with or those I serve? Could it harm trust, credibility, or teamwork? If the answer might be yes, pause, because once words are public, once they're heard, once they're seen, you can't take that back. And employers aren't policing beliefs, not your personal beliefs. They're protecting environments. For HR professionals and employers, Hedgepeth highlights a growing reality: the line between personal expression and workplace conduct, it's thinner than ever. When an employee's public statements target protected groups or contradict an organization's values, employers can't always ignore it, especially when the speech spills into the workplace and creates tension or fear. Employers have a duty to prevent hostile or disruptive comments, not only inside the building, but in situations connected to the workplace. But here's the caution: document actual disruption. Don't overreact to one complaint or media pressure. Apply policies consistently. The same standard has to apply regardless of whose opinion is unpopular. Avoid what we call the heckler's veto. In other words, don't punish speech just because it's controversial. Focus on whether it impairs workplace function, workplace relationships, and causes disruption. We're living in such a politically charged time right now that it's difficult to share anything without being labeled. And for employers, that creates real challenges in maintaining respectful, inclusive environments.
I hope this video is giving you some insight into how free speech issues can play out at work and what both employees and employers can do to manage those situations responsibly. Thanks for watching the HR Insider. If you found this helpful, don't forget to like, subscribe, and share this video. We're seeing these things play out not just in court, but in the workplace. If you're an HR professional, check out my free compliance resources and workbooks linked below. Until next time, I'm Harlow Reed reminding you, real cases, real lessons for real people.